Hi everyone, welcome to Beyond the Evidence. This is the channel where justice matters. My name is Marv. I am a true crime fanatic, and I love to dig deeper into the mysteries of unsolved cases. Join me as we search for missing persons, uncover the clues in unsolved murders, follow along with jury trials, and we'll be a voice for the voiceless. I'll share with you the facts, the theories, the clues, the evidence, and the controversies that surround these cases. This is Beyond the Evidence. Good morning or afternoon, wherever you are. Welcome to Beyond the Evidence. We're here to talk about the Delphi murder case and the judgments that the Judge Gull made last week. She has put the confessions in, allowing that to come into the trial, and has denied the defense the third party defense that they had planned. In retaliation, the defense has put in a motion for the court to certify court orders for an interlocutory appeal pursuant to Appellate Rule 14 and request to rule expeditiously on said motion. What does that mean? Well, the defense wants the judge and the Supreme Court to hear an appeal before the trial even started. Once again, they are looking to the Supreme Court to issue a ruling in this matter. In most interlocutory appeals, the Supreme Court will not hear it. But because this is a unique case and a unique situation, we'll have to wait and see what they say. But for today, we're going to read through this motion, and then we're going to discuss what the ramifications could be. So let me put this on the screen. I'm going to share it with you as I read it. It is 17 pages. Welcome everyone that's been here from the start and everyone that's entering. Let's get started on reading this. Motion for court to certify court orders for interlocutory appeal pursuant to Appellate Rule 14 and request to rule expeditiously on said motion. Come now the accused, Richard Allens, by and through counsel, and moves this court to certify the September 4th, 2024 court order granting the state's motion that prevents the defense from presenting certain evidence, and the August 28th, 2024 order denying the defense's motion to suppress certain statements made by Richard Allens for interlocutory appeal pursuant to Indiana Rule of Appellate Procedure 14. Furthermore, the defense would request this court to rule expeditiously based upon the October 14th trial date. In support of said motion, Allens states the following. The Indiana Supreme Court has recognized that orders to limine have historically been eligible for interlocutory review. Orders in limine are eligible for discretionary interlocutory appeal, Means 2 versus State 201. Orders in limine are eligible for appellate review under Appellate Rule 14b to the same extent and with the same prerequisites, trial court certification, and Court of Appeals acceptance as any other interlocutory order. The tentative nature of orders in limine does not result in the categorical exclusion of those orders from discretionary interlocutory review, which is why our appellate courts have long reviewed orders in limine through interlocutory appeals. 2. In the past, interlocutory appeal concerning motions in limine have also been allowed to the benefit of the prosecution. See State versus Harold Lewis. After the trial court granted the defendant's motion in limine, the state of Indiana received an order in limine preventing the prosecution from presenting certain evidence. The trial court then certified the order for interlocutory appeal, and the Court of Appeals then accepted the order for interlocutory review, ultimately reversing the trial court's ruling. 3. The denials of motion to suppress are also eligible for interlocutory appellate review. See Kelly versus State. Direct review of the denial of a motion to suppress is only proper when the defendant files an interlocutory appeal. Number 4, the defense contends that the court's September 4, 2024 order denied Richard Allens right to present a defense in violation of the Sixth Amendment to the United States Constitution. Furthermore, the defense contends that the court's September 4, 2024 order denied Richard Allens his constitutional right of the following provisions of the Indiana Constitution. Section 12. All courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. Section 13A. In all criminal prosecutions, the accused shall have the right to a public trial by an impartial jury in the county in which the offense shall have been committed, to be heard by himself and counsel, to demand the nature and cause of the accusations against him, and to have a copy therefor, to meet the witnesses face to face, and to have compulsory process for obtaining witnesses in his favor. Section 19. In all criminal cases, whatever, the jury shall have the right to determine the law and the facts. Furthermore, as to the alleged confession of defendant Allens, the defense contends that the court's August 28, 2024 order denied defendant Allens of his 5th, 6th, and 14th Amendment rights under the U.S. Constitution, as well as his constitutional rights under Article 1, Section 12, 13, and 14 of the Indiana Constitution. Number 7, if this court has erred and the determination of the error is withheld until after judgment, then the appellate victims' families and citizens of Carroll County will suffer substantial expense and damage as follows. Richard Allens will suffer continued incarceration while awaiting the ruling from the Court of Appeals. B. If Richard Allens is convicted without interlocutory appeal, then he, as well as the families of the victims, would first suffer through the anticipation of a ruling from the Court of Appeals of Supreme Court on these critical issues, and then whether a reversal will result in a second lengthy trial. If the appeal is regular course, not interlocutory, results in a reversal, then Richard Allens and the victims' families will have to endure a second lengthy trial. Also, the taxpayers of Carroll County will suffer substantial cost, perhaps in the millions of dollars, between appellate costs, attorney's fees, expert costs, and costs for security in 2 different counties based upon a second trial, as well as time of all the parties involved, including the trial judge, prosecutors, defense attorneys, law enforcement, family members of the victims, and others who will all sit through a second lengthy trial. Additional costs associated with sequestering a jury during the second trial would also be significant in both expense and time. Moreover, and this is D, moreover, the prosecution of defendant Allen has brought about worldwide attention in nearly every form of media coverage, as well as extensive coverage by various social media platforms. The disclosure of facts and information, including many facts unknown to the public, even to this day, at a jury trial will result in the consumption of this information by those reporting sources. The dissemination of this information to the public, which will undoubtedly occur, will make it more difficult for defendant Allen to find unbiased jurors in the event of a retrial. Defendant Allen's detention circumstances are unlike any other pretrial detainee, perhaps in the history of the state. He has been and continues to be isolated from any sense of normal contact with the outside world, with the exception of his ability to make monitored phone calls to his family. This has been the case for nearly 2 years. To the extent a retrial would occur, defendant Allen's detention circumstances would place further burdens on him and the facility in which he is housed. This workload would be compounded and would likely require months and months to organize, review, and prepare for a second trial. F. The voluminous discovery offered by the state, deposition transcripts resulting from discovery conducted by the defense, and mounting number of transcripts stemming from the pretrial hearings have resulted in a monumental amount of trial preparation for both the state and the defense. G. If a second trial were to occur, the compounding of discovery, transcripts, and other related materials stemming from this case would place extraordinary burdens on the state, defense, victims' families, defendant, and defendant's family, not to mention the judge and court staff members in both Allen County and Carroll County. Law enforcement officers from the various investigating agencies would be required to continue to exhaust their time and resources, even beyond the 7 years that has already passed since the crimes were committed. And finally, the additional expenses to be borne by the taxpayers of Carroll County would continue to mount. It is for these reasons that the interlocutory appeal addressing the issues of defendant Allen's pretrial detention and incriminating statements allegedly made by him thereafter is appropriate. H. Additionally, should this court not allow these issues to be heard by the Court of Appeals in an interlocutory fashion, then during the jury trial set to begin October 14th, 2024, the jury will be sitting for hours, or perhaps even days, while the defense presents its evidence in an offer of proof. Whereas, should the Court of Appeals find that the trial court was in error, then the jury will not be forced to wait outside the courtroom or in their hotel rooms for hours or even days while the defense presents its offer of proof. The trial will run more efficiently and at less expense should these issues be resolved by the courts of appeals before any trial takes place. Okay, I'm going to stop right there. If the defense had more evidence to bring in the onus theory and all of these individuals that they think are the cause of this crime, that committed this crime, why didn't they present more evidence at the hearings other than Pearl Nutter's testimony? Why didn't they go the extra mile and present more of this evidence. The reason the judge granted the motion in limine, eliminating the third-party defense, the ritualistic killings, the cults, and the individuals named in the motion of limine, is because she said the defense did not prove that these individuals were there and committed the crime. If they're saying, if the defense, if Baldwin and Rozzi are saying that they have the evidence, why didn't they present it at the hearing to make sure that the motion of limine wasn't granted? They should have. So now, because they didn't do their job and present all of their evidence supporting this defense, they're bringing it to, first, Judge Gull has to approve this interlocutory appeal and say, okay, go ahead and send it to the Supreme Court. And then the Supreme Court needs to review it, have a hearing, if they choose to have a hearing, and make a decision. Or they're just going to reject it completely. Let's move on. Number 8, this court's August 28th, 2024 order and September 4th, 2024 order both involve substantial questions of law, and the early determination of those issues will promote a more orderly disposition of the case. To wit, the September 4th, 2024 order denies Richard Allens the ability to present a defense, violating both state and federal constitutions. No, it does not deny Richard Allens a defense. They can put on a different defense. They have that right. But they have thrown all of their cards in one basket, where there is no evidence. And the detectives that looked into the Odinist theory stated there is no evidence that these individuals were at the Monon High Bridge the day that this crime was committed. All of the evidence, the witnesses, the bullet, the car, him putting himself there, his confessions with specific details of the crime point to Richard Allens doing this. Why doesn't the defense, why haven't they come up with a second defense to try to get around those issues? They should have. But instead, they decided they were going to go this route, and they were in it to win it, and now they're losing, so they're appealing to the judge and to the Supreme Court to listen to this and reverse the judge's decision. My question is, if they send the same information that they gave in the hearings to the Supreme Court, what makes them think that the Supreme Court is going to overrule the judge's decision when they have no specific evidence that these individuals were at the Monon High Bridge at the time that Abby and Libby were there, and at the time that these crimes took place when the girls lost their lives. Claiming they didn't have time to do so is a cop-out. They should have been preparing one defense, this ritualistic killing, and at the same time, they should have had a plan B all this time. Especially knowing and being told by the judge that she is very aware of how a third-party defense should be presented and what evidence they need in order to present it. She warned them a long time ago. You're all right, Gibbo. Just passionate about this. Okay, let's continue with number 9. On September 18th, 2023, the defense filed the first Frank's notice, at which time the defense received in great detail its defense that Odinism, Norse paganism, explained the unusual nature of the crime scene and furthermore identified particular suspects who were tied to the victims and or tied to the crime scene. Okay, you've given us these names. You've given us your theory. But, defense team, you have not provided any evidence whatsoever that these individuals were at the crime scene when the murders took place. None whatsoever. And several law enforcement officers who did investigate this angle also have stated there is absolutely no evidence to put any of these individuals at the crime scene. All right, number 10. The September 18, 2023 Frank's notice was very transparent and left no doubt that the defense would be claiming that A, Odinism, Norse paganists were involved in the murders of the victims. B, law enforcement began investigating the links between the crime scene and Odinist Norse paganism within 3 days of the murders. C, that law enforcement began investigating Brad Holder and Patrick Westfall as suspects within 3 days of the murders. Sorry, I have a tickle in my throat. Well, what we learned from reading the testimony is that that was not true. Police talked to Brad Holder because Brad Holder's son was the boyfriend of one of the victims and a very good friend of the other. They talked to Logan Holder and got information from his phone to help them find the missing girls. Investigators stated in that testimony that they did not know about this Odinism and paganism stuff until after they initially talked to Brad Holder. C, that law enforcement began investigating Brad Holder and Patrick Westfall as suspects within 3 days of the murders. D, that at least 3 law enforcement officers continued to investigate into the Odinist Norse paganism ties to the murders, and particularly ties between Brad Holder, Patrick Westfall, and certain men in Rushville, Indiana, to the murders. E, that Richard Allen has no connection to Odinism, Norse paganism, and therefore could not have left signatures of Norse paganism at the crime scene. 11. In spite of the prosecutor knowing defendant Allen's third-party defense on September 18, 2023, the prosecution waited over 7 months before filing its motion in limine on April 29, 2024. The prosecution's motion was filed 15 days from the May 14, 2024 trial setting. On April 29, 2024, the prosecution filed its motion in limine requesting in paragraphs 7A and 7B that the court prevent the defense from presenting evidence that explains the defense's belief of what the crime scene shows, i.e., that certain signatures the killers left at the crime scene revealed that a ritualistic killing occurred at the hands of Norse paganist Odinist. Because Richard Allen has no ties to Norse paganism nor Odinism, the evidence the state of India sought excluded would prevent Richard Allen from arguing that Richard Allen did not commit the murders, as he knows nothing about Norse paganism and therefore would have no motive nor knowledge to leave signatures of Norse paganism behind. On August 1st, 2024, the defense presented evidence through expert witness Dawn Perlmutter that the crime scene was a textbook ritualistic killing. This opinion was offered from an expert who literally wrote the book on analyzing a crime scene for a ritualistic murder and also has taught FBI and other law enforcement agencies all over the country what a ritualistic crime scene looks like. Furthermore, Dr. Perlmutter has almost exclusively worked for law enforcement and prosecution, not for the defense. The jury would be able to assess the weight to give Dr. Perlmutter's assessment of the crime scene. Furthermore, in its April 29, 2024 motion in limine, paragraphs 7C and 7D, 7E, 7F, 7G, and 7H, the prosecution requested the court to prevent the defense from presenting evidence that tied alternative suspects involved in Norse paganism, Odinism, to the murders, including evidence of the investigative efforts of 3 law enforcement officers who believed that the evidence credibly pointed the finger at certain third-party suspects, and also social media posts that provide a nexus between certain third-party suspects and the murders. Okay, yes, 3 officers continued to investigate this angle. But once again, there was no proof that these individuals were at the crime scene at the time that the crime happened. The defense has not provided any evidence that shows that these individuals were there at the time this took place. If they had that evidence, they would have presented it in the 3-day hearing. Just saying that again. Number 13. Furthermore, in its April 29, 2024 motion in limine, paragraphs 7I and 7J, the prosecution requested the court to prevent the defense from presenting evidence that third-party suspects Keegan Kline and Tony Kline committed the murders. Even though credible evidence exists that A, Keegan Kline had arranged to meet one of the victims on the day of the murders, B, Keegan Kline implicated his father, Tony Klein, as being involved in the murders. C. Law enforcement tried to tie Richard Allen to Tony Klein and arguably only interrogated Richard Allen because of law enforcement's initial belief that Tony Klein and Richard Allen knew each other and committed the crimes together. D. Law enforcement officials discovered a cache of child pornography on Keegan Klein's personal cell phone during the course of their investigation. And E. Law enforcement officials actually transported Keegan Klein to an area near the crime scene to corroborate his version of what he and his father Tony did near the crime scene on the day in question. Okay, hold up. Was it Keegan Klein and Tony Klein that killed him? Or was it the Odinist or the Paganist? I'm confused. Because now you're saying all this time it was a ritualistic killing. And this was done by Odinist and Paganist. But now you're saying that Keegan Klein and his dad did it? Which one is it? Furthermore, in its April 29, 2024 motion in limine, paragraph 7K, the prosecution requested the court to prevent the defense from presenting evidence of third-party suspect Ron Logan, even though credible evidence existed that A. The bodies were found on Ron Logan's property, B. FBI authored probable cause affidavit stated that Ron Logan placed a phone call on or around his property around 2:09 p.m. using cell tower data. 2. Ron Logan provided false information about his activities during the time the crimes were committed and employed others to assist in deceiving law enforcement, and furthermore plotted an alibi for a crime that has not yet been discovered. 3. A court found that said probable cause affidavit provided probable cause that evidence of the murders would be found on Logan's property. 15. Furthermore, in its April 29, 2024 motion in limine, paragraph 8, the prosecution requests the court to prevent the defense from presenting evidence from law enforcement officer Todd Click, who investigated the Norse Paganist Odinist ties to the murders, as well as the ties of certain third-party suspects to the crimes, primarily those identified in paragraphs 7A through H of the state's motion in limine. Click's testimony would provide evidence that connects those third-party suspects to the crimes, as would the testimony of law enforcement Kevin Murphy, who also investigated said connection alongside Click, including the testimony that Elvis Fields posed the question to him of Elvis's spit would be found on the girls, but he could explain it. Would he, Elvis, be in trouble? Furthermore, Murphy would be able to tie Elvis Fields from Rushville, Indiana, to Brad Holder of Logansport, Indiana, and that Brad Holder was an active Odinist whose son, Logan Holder, dated one of the victims, and who also had changed his story multiple times about whether he had ever met the victims, and whose social media posts included evidence that tied Holder to the crime scene. So if the defense truly believes Elvis Fields, where's the evidence that there was spit found on one of the girls? Because that spit would contain Elvis Fields' DNA and put him dead to rights to that crime scene. Where is it? They haven't offered it. Furthermore, in its April 29, 2024 motion in limine, paragraph 9, the prosecution requests the court to prevent the defense from presenting evidence of geofencing, even though the geofencing evidence provided evidence that other third-party suspects were in the area of the crime scene at the time the prosecution is claiming that the crimes were committed. Okay, so you're saying you have this evidence showing that these individuals were in the area? In the area. But it does not state that they were at the Monon High Bridge at the time that the girls were crossing the bridge, and it does not state that they were on Ron Logan's property at the crime scene. In the area isn't good enough. You have to pinpoint it and close the gap. 17. After the May 13, 2024 trial date was continued, the court held the hearing for said motion in limine on August 1st, 2024. And likely because of the voluminous amount of evidence it received and reviewed, the court was unable to rule on the state's motion in limine until September 4th, 2024, which was 40 days before the scheduled October 14, 2024 trial date. Included in the court's ruling was the court's belief that the admission of evidence would confuse the jury. The defense respectfully rejects that premises. Evidence that the court excluded from the jury would actually provide the jury as understanding explanation of why the crime scene appeared the way it appeared. In fact, the defense would argue that by keeping the evidence of Norse paganism from the jury, the jury, would be confused as to why the crime scene appeared the way that it appeared. Additionally, the inclusion of evidence of third-party suspects as being connected to the murders is not confusing, but rather easy to understand, and that it's up to the jury to either accept or reject the defense's contentions that the evidence connects Norse paganism, Odinism, and third-party suspects to the crime. Now, I would agree with that if the defense had specific evidence showing those individuals were on the bridge and on Ron Logan's land, where the crime scene was. But since none of that has been offered, their defense of this ritualistic Odinism, paganism, is too broad. They haven't zoned it in enough and provided evidence. And that is why the motion of limine was granted. Essentially, with its September 4th, 2024 order, therefore 40 days before the trial is scheduled to begin, Richard Allens' defense was completely gutted. I will agree with that. Certainly between the Frank's notices that have been filed and were made part of the record and the exhibits that were attached to those filings, as well as the evidence and testimony this court received during the July 30th through August 1st, 2024 hearings, the Court of Appeals would have more than enough record to review to either support or negate this court's September 4th, 2024 order, as well as the August 28th, 2024 order. The issues to be presented to the Court of Appeals for interlocutory appeal concerning paragraphs 7, 8, and 9 of the State of Indiana's April 29, 2024 motion in limine would all involve whether the trial court was correct in granting the state's motion in limine, thereby denying the defense the ability to present evidence, A, concerning its interpretation of the crime scene and how said interpretation excludes Richard Allens as a suspect. B, concerning whether a nexus existed between certain third-party suspects and the crimes, and C, whether evidence presented warranted the court from excluding geofencing evidence. The August 28, 2024 order denying defendant Allens' request to suppress incriminating statements violates Allens' state and federal constitutional rights. On November 3, 2022, Judge Benjamin Diener issued a safekeeping order which resulted in defendant Allens' immediate transfer to a maximum security IDOC confinement facility wherein he was detained in solitary confinement for a period of nearly 13 months. Defendant Allens was not afforded a due process hearing regarding his detention until June of 2023, nearly 8 months after he was locked away in solitary confinement. Throughout the course of defendant Allens' detention, the state of Indiana began offering up discovery in the form of incriminating statements made by defendant Allens to prison guards, inmate companions, the warden, defendant Allens' treating psychologist, and defendant Allens' family members. Defendant Allens then moved to suppress the admissibility of said statements on the basis that said statements were involuntarily made and thus obtained in violation of defendant Allens' 5th, 6th, and 14th Amendment rights under the U.S. Constitution. Defendant Allens also asserted that his rights under the Indiana Constitution, Article 1, Section 12, 13, and 14 were violated. On August 28, 2024, the Honorable Court issued the amended order or judgment of the court denying defendant Allens' request for suppression and holding in totality that the statements given by the defendant to various individuals were not coerced, were voluntary, and were not the result of interrogation by the state or its actors, nor the product of his confinement. With regard to the August 28, 2024 amended order, the issues to be addressed are as follows. A. Was Richard Allens denied his right to due process under both the state and federal constitutions when he was detained in solitary confinement without having them afforded a timely hearing on the state's motion for safekeeping order? B. Did the effects of defendant Allens' extended solitary confinement render statements made by him to the prison guards, inmate companions, the warden, defendant Allens' treating psychologist, and defendant Allens' family members involuntary and therefore inadmissible at trial? Were the statements allegedly given by defendant Allens to his treating psychologist, Dr. Monica Walla, privileged pursuant to IC 344631? The August 28, 2024 order involves a substantial question of law that could be resolved on appeal and lead to a more orderly disposition of the case. Defendant Allens' incriminating statements stemmed from a most unique detention circumstance. Allens nor his counsel were given no choice in the matter. The issue of first impression here is whether or not defendant Allens' due process rights were violated, i.e., does the safekeeping status require the court to conduct a hearing to address the propriety of defendant's pretrial detention circumstances. Defendant Allen is unaware of any rulings in the state addressing this very issue. If the Court of Appeals were to find in defendant Allen's favor the admissibility of statements and other evidence stemming from defendant Allen's wrongful detention would be inadmissible. The normal remedy of a direct appeal is not adequate. The remedy of an appeal is otherwise inadequate for all the reasons stated herein. Because of the pending trial date, the defense would further request that this court issues its ruling on this motion as expeditially as possible. The state of Indiana has been contacted and objects to the request, but waives the 15 days to respond, as they have indicated that the prosecution will promptly file their objection. Based on the pending trial date, the defense would respectfully request this court to rule on this matter as expeditiously as it can, and believes the prosecution would also benefit from an expeditious ruling. This motion is not made to unnecessarily delay the trial, but out of a sincere belief that the court's ruling is erroneous and will result in an unnecessary second trial should Richard Allen be found guilty. Wherefore, Richard Allen, by and through counsel, would request this court to certify the issues presented herein for interlocutory appeal to be heard by the Indiana Court of Appeals. So what is everybody's thoughts on this? Basically, the defense is stating this appeal should be heard before the trial because A, it would cause another trial to happen if the Court of Appeals waited till after the trial was finished. B, it would be cumbersome on the families, the prosecution, the defense, and the defendant to go through a second trial. C, it would cost more money for Carroll County, the defense, the prosecution, and the families. I agree with Gull's decision on the motion of limine. I do not feel that Perlmutter's testimony was enough evidence to prove a third-party defense. Just because she comes on the witness stand and states that you have all these things in common with the crime scene doesn't make it so. You could look at any case going on now, if that were the case, and say that they were ritualistic killings by Odinist. All right. I hope she denies it. That sounds like a threat to disrupt and delay. Even though they put in there that they're not trying to delay it. Yep, we went through that one. Also couldn't prove that any of the individuals were in Delphi at the time of the crime. Right. But, as I said, Frank, if the defense truly wanted to do this third-party defense, okay, in my experience of watching all of these trials and listening to them, they cannot just broadly present evidence of this. They have to have specific evidence showing that one or more of these individuals was on the bridge at the crime scene. They can't just broadly say they were in the area. I mean, in the area could mean so many different things. And I know I've said that over and over again, but I want people to make sure that they understand that. Let's see here. Accusing TK won't sit well with some RA supporters. Well, and in my opinion, they can't have it both ways. You can't vehemently state that this was a ritualistic cult killing and then turn around and say TK and KK, Keegan Kline and Tony Kline did it, or Ron Logan did it. You still have to have evidence proving that they did it. Berlin says they're just blaming everyone at this point. Just put all those guys in the mix. The defense is ridiculous, wasting everyone's time with their circus act. LE investigated all these third-party folks and couldn't find evidence. Plenty of evidence against RA, though. I agree. For all the money, $100 an hour, delay, create drama, book deal. Yeah. Stall tactics. Just because she could deny, the defense can still file with the appellate court. Right. RL lives on the property, so he would be in the area. Correct. Okay, so I'm going to bring up a YouTube video. So let me get that up here for you. Because this morning I did watch a few videos regarding this. And I thought this video was one of the best ones that I watched. Explaining all of this. Okay, I've got it here. This is attorney Mark Lopez. We've heard from him before, but I wanted you to see what he has to say. So let's get into this video.
On trial for murder, and the trial judge says you're not allowed to point the finger at alternative suspects. That is exactly what the defense team is saying is happening today in the Delphi Murders case. Hi, I'm attorney Mark Lopez. I'm an Indiana criminal defense attorney of nearly 20 years, and let's break down what's going on in this case. In the past couple of weeks, there's been two significant rulings on Delphi Murders case. Number one, on August 28th, the judge said all confessions made by Richard Allen are coming into trial. And then a few days later, on September 4th, trial judge said, hey, defense team, you are not allowed to talk about any third-party perpetrators. You can't point the finger at anyone else that may have done this crime. The defense team has responded that their entire defense has been gutted less than 40 days from the start of this criminal trial. The defense team wanted to kick out the confessions because they're saying that the confessions were involuntary on the part of Richard Allen. Now, there's a lot into this, but basically the conditions in which he was held were so terrible that basically he lost the ability to do this of his own accord. That's number one. Now, number two, the defense team also wanted to point the fingers at various individuals with ties to Odinism or other paganistic religions and basically say, hey, Richard Allen has no connection to these type of religions, therefore he could not have participated because these murders were done in a ritualistic fashion. They also have some geofencing data that shows people were in and around the crime scene when these murders are said to have occurred. This is a pretty big deal if you're a defense attorney because you get to point at somebody else and say, hey, that's my client, but here's some other evidence. This is powerful stuff. And the judge has completely blocked that and said the confessions are in, third-party perpetrators is out. Now, the defense team has not taken this lying down. They have filed late in the evening on September 9th a motion for...
Okay, I'm going to stop it there real quick because now he's saying the defense has geofencing evidence that puts these people there at the crime scene and at the trail. That's not what their motion said. Just said in the area. So I don't know if Mark is right on that or not. Just keep that in mind.
Interlocutory appeal. What is an interlocutory appeal? Let's break it down a little bit. A normal appeal occurs after a case is over. So there's a verdict, and then the person that lost, presumably the defendant, would say, hey, Court of Appeals, we have a few issues, 1, 2, and 3. Let's figure this stuff out. Now, that's normal appeal. An interlocutory appeal is basically saying, hey, the case isn't over, but we disagree so much with the trial judge's position that we would like the Court of Appeals to review this and give us their opinion before we move forward. So interlocutory appeals are not very popular with the Court of Appeals because, well, the case isn't over. Why?
Very good point. Interlocutory appeals are not very popular with the Court of Appeals.
Why would you want to have them do it twice? Interlocutory, and then if someone proceeds to trial, they do it again. So they're not very common, but they do happen. This type of interlocutory appeal is what's called a discretionary interlocutory appeal. And what that really means is the defense team needs to convince the trial judge to sign off on the interlocutory appeal. And that's why you see this 17-page motion for interlocutory appeal, because they're actually trying to actively convince the trial judge to grant them the interlocutory appeal. And if the trial court judge does grant the interlocutory appeal, story's not over. Because it's discretionary, the Court of Appeals also has to sign on the dotted line and grant the interlocutory appeal. So the defense team has to convince the trial judge and the Court of Appeals to take this up on interlocutory appeal. That is an uphill battle. I have asked for interlocutory appeal numerous times as an Indiana criminal defense attorney. I have been successful in getting a trial judge to grant the interlocutory appeal numerous times. I have yet to ever get the Indiana Court of Appeals to accept an interlocutory appeal because, again, they have plenty of their own work to do on final cases. Why would they want to mess around with cases that aren't final?
Okay, that's huge. This man is an attorney in Indiana, and he just said that he's gotten many judges to sign off on the interlocutory appeal, but he has never had the Supreme Court sign off on one. That's huge. That is so huge. Because like he said, why should they do it twice? Do it now and do it after, when the appeal comes after the trial's over.
This case obviously is a little bit different than some of the cases I've done, and there's a better shot than most for interlocutory appeal to be granted by both the trial judge and the Court of Appeals. So let's talk about that. And you'll see the criminal defense team, it's a 14-page memorandum, and I counted, about 75% is talking about the exclusion of third-party perpetrators, about 25% is talking about the confessions. That's kind of where we're at. And the confession stuff, the law is against them. It just is. But as they state in their memorandum or motion, this is a first impression arguing that these living conditions are so terrible to override the free will of Richard Allens. So using those words, first impression, that's a signal to the trial judge and the Court of Appeals, hey, this is important and this is not an established area of law. I don't know how this is going to turn out because the law is against them, but it's a very unique circumstance. Now, the majority of the motion for interlocutory appeal talks about the third-party perpetrators. And essentially, Indiana, you have the right to present a defense. And by saying you're not allowed to point the finger at somebody else, there's no real defense left for the defense team. And you'll see in one of the paragraphs of the motion, the prosecutor is going to object to this interlocutory appeal. Of course, the prosecutor is going to object. I've done hundreds of trials, hundreds of suppressions, and I have only had one prosecutor in all those hundreds and hundreds of cases raise their hand and tell the judge, Judge, it looks like Mark's right. Hold on, let's set this out for briefing. One. Of course, the prosecutor is going to say how they object. So let's talk about why the defense team argues that a trial judge should grant interlocutory appeal. Number one, basically the defense is gone. Less than 45 days from trial, the defense is gutted. They're saying they have nothing to work with if they kick out all these things. And so obviously this is going to get appealed if they lose. Every single filing done by the defense team, in my opinion, has been with an eye towards appeal, knowing that this case is going to be appealed, and they don't want a situation where the Court of Appeal says, you should have brought this up to the trial judge's attention. That's why we're seeing so many voluminous things getting filed by the defense team with so many details. They want the record to be very clear that they are bringing things to the attention of the trial judge. So the number one issue, in my opinion, is the fact that this case is basically done if they can't point the fingers at somebody else. Number two, if they have to redo this trial, it's going to be very expensive. They're already transporting jurors, paying juror fees. It's expensive not only in money, but also time, trying to catch up on things. Just redoing the trial is going to be so expensive. Whereas if they do the interlocutory appeal now, there will be one less issue to appeal in the event Richard Allen loses that trial. The third reason, in my opinion, is they argue that the world is watching and basically saying someone's not allowed to defend themselves. Well, that doesn't look too good on the Indiana criminal justice system. So the fact that the world is watching is a reason for the court of appeals and the trial judge to grant interlocutory appeal. And the fourth reason is the human cost. These were two little girls with people that love them, and to make the victims' families have to go through this more than once seems very mean and cruel. So those are the crux of the arguments for the granting interlocutory appeal now, as opposed to making them go to trial and appeal later. Now, the arguments against interlocutory appeal is this case is old. Now, some of this delay is attributable to the defense. Some of the delay is attributable to the judge taking her time on making these rulings. And I'm not criticizing the judge because these are some pretty important rulings she's making. She needed time to research, hear arguments and whatnot. But the case is old, at least for Indiana. Other states move things a little bit slower. Some states move things faster. But Indiana, this case is a little bit old for this type of situation. And then another argument against interlocutory appeal is the trial judge very well might think she's right. I've had judges when I've asked for interlocutory appeal, be like, hey, Mark, it's a close call, so I'll give it to you. You can ask the court of appeals to see what they want to say. But if this judge truly believes she is doing the right thing, then she might say, I'm going to win anyway. The trial judge in this case is established. She's been doing this for a very long time. She's likely seen scenarios similar to this. And if she thinks she's right, she might say, no, let's just keep going on here. And you guys can argue about it later, but I'm right. Even if the trial judge signs off on all of this and they submit it to the court of appeals can still say no. So, interlocutory appeal is a lot of extra work. And, there's an argument to be made. Do they work on interlocutory appeal or do they focus on the trial? If interlocutory appeal is granted by the trial court judge, inevitably there's going to have to be a continuance of the trial. They can accelerate deadlines and they could say, hey, we're going to keep this trial date, see what the court of appeal says. So it's very possible we have the criminal court granting interlocutory appeal and they say, we're going to keep that trial date to see what the court of appeal says. Because the court of appeals could make a decision in 45 days. In my experience, it takes a lot longer than 45 days for a court of appeals to decide an issue like this. But they could say, hey, there's some gravity in getting things done fast. So it's up in the air if there's going to be a continuance. And, if I was the attorney on this case, I would ask for a continuance to pursue the interlocutory appeal if the trial court judge grants it. Trial court judge could say yes, court judge could say no. I am dying to see what's going to happen next in this case because there's so many twists and turns. What do you think? Do you watch this video this long? Like and subscribe.
So what do you think about what Mark Lopez said? He gave you the reasons for the appeal and against. And one of the things that he said is because this case is so old. Richard Allen was arrested 2 years ago. He's right. It is old. I guess the biggest question for the Supreme Court is, do they want to look into this now? Or are they going to say, absolutely not, we'll look at everything at the end? That's going to determine whether this trial is delayed or not. I bet you they got him on Libby's phone and a whole lot more that has not been brought out. I agree. I think that we're going to hear some more about witnesses. They want this to be denied. They want one more thing that Gull denied. Yeah, I agree. I much prefer lawyer. I absolutely love him. He gets the law up and explains why the judge makes the decisions and also uses the past cases to explain what he thinks will happen. Absolutely. I love Peter. Watch him all the time. If I find a video that he does on this, I haven't checked his page today, but if I find one, I will share it on the Facebook page, the Facebook group, and in Discord. So, with that being said, all of those pages, the Facebook page, the Facebook group page, and Discord are listed in the description below the video. So, what are we betting on? Are we saying that the judge, first, it all starts with the judge, Judge Gull. Is she going to allow them this interlocutory appeal, or will she deny it flat out? If she denies it, we go straight to trial in October. If she approves it, they send it to the Supreme Court. Then it's up to the Supreme Court. Are they going to hear it and make a decision on it and delay the trial? Because that's the key. Or are they going to deny it and say, no, all of your appeals have to be made after the trial's over? And then once again, we continue with the trial in October. What are all of your thoughts? Let me know in the chat, in the comments below. 1, do you think Judge Gull is going to grant this or deny it? And 2, do you think the appeals court is going to grant this or deny it? Now remember, when the appeals court had the hearing about the defense's attorney, one of the things they said is that they did not want to delay this trial any further. And that is one of the reasons why they put Brad, Rozzi, and Baldwin back on the case. Are they going to go with that again and deny it? We're going to have to wait and see. I'm hoping that we'll have a decision from Gull by the end of this week or early next week. And then we're going to have to wait on the Court of Appeals, depending on what she says. Silas says, I think it will be denied by both. Gibbo says, right, save some women for the rest of us, Pete. Gigi says, there are options. They can go straight to another appeal and Supreme Court. We'll see. They're saying they do not want to delay the trial in their motion. I read it at the end. So we'll have to wait and see. As soon as I hear anything else on this, I will get online and share it in the Facebook group, the Facebook page, and in Discord, and on the community page. And then I'll probably do a short live on it. So yes, I do agree, Gibble, that these are things usually done after trial. And you're right. The courts will want to see how Judge plays it out. Because she did leave the door open for him. She said that if they could provide more specific evidence, that they could present that during the trial away from the jury, and she would consider it. Thank you all for joining me this morning, this afternoon, early afternoon. I know this isn't my usual time, but I'm happy that you were here and that you were able to hear and read, because this is on the Facebook group. This motion is on the Facebook group in the files and in Discord. So if you want to read it for yourself, you absolutely can. But we got through the motion, all 17 pages. I did give my thoughts in some of those parts. So if you missed it, go back and watch it. And I'll keep you updated. Join me tonight, because I have found a resource that each and every one of us can use on missing persons cases and unsolved murders. And I want to share that resource with all of you. Have a good day, and I'll see you tonight. Remember, justice matters. Bye, everyone.